When your medical malpractice case comes on for trial, how do we know which witnesses will be coming in to testify against us? Would you like to know the answer? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. In a medical malpractice case in New York, each side has an obligation to disclose to the other side which witnesses we are going to be bringing in to testify. Now you might be saying, wait a second, I thought that we don't have to disclose the names of our experts, our medical experts. And you know what? You are absolutely right. In New York, in a medical malpractice case, we do not disclose the name of our expert who is going to be coming in to testify, or I should say experts, if we have more than one. The defense, likewise, does not have to disclose the name of their experts either. However, we are required to disclose to the opposing side that we have an expert who is a specialist in this particular medical field. And then we have to explain to our adversary exactly what this witness is going to be talking about. Likewise, they have to do the same exact thing. Now, what's most remarkable is that each side, even though we don't disclose the name or names of our experts, medical experts, there is a way to go ahead and learn and find out exactly who this particular individual is. And most of the time, each side is pretty successful in identifying who those witnesses are. But what if there are other witnesses? What if there are factual witnesses who are going to be coming in to testify? Do I have an obligation to notify my adversary that we're bringing in a fact witness to go ahead and explain what occurred at a particular time, at a particular day? The answer is, yes, I do. I do have that obligation. And you might be wondering, okay, what happens if I fail to notify my opponent that I'm bringing in a particular witness? Well, a couple of things will happen, and none of it is good. None of it is good for our case. If we are at trial, and now for the very first time I alert my opponent to the fact that we have a fact witness who heard a specific conversation between you and the doctor, which basically confirms a lot of what we are saying, and I did not notify my opponent, my adversary, before the trial about this witness, you know what the judge is likely going to do? The judge will likely prevent me from allowing this witness to testify. It's called precluding the witness. Why? Because number one, I failed to notify my opponent of this witness. Number two, I failed to give him the opportunity to learn from this witness by a deposition, by questioning him in a question and answer session to learn exactly what information this witness had. If I had done that, and he went ahead and properly deposed this particular witness, now he would be no longer able to argue at the time of trial that it's unfair to him to allow this witness to testify. Why? Because by the time we get to trial, he will already know exactly what this witness has said. He will be able to prepare a strategy addressing what this witness has said together with his client, the doctor. And now there's nothing unfair about it. He knew about it. He knows what the witness has to say. And now I can go ahead and call this witness to testify. Are there any other witnesses I have to notify my opponent about? Yes. If I'm going to bring in an economist, someone who's talking about the value of money. If I'm going to bring in an economist, an expert who is a specialist in understanding and explaining the value of money over time, that is critically important to notify my opponent about. Likewise, if he's going to bring in an economist, he has to do the same thing to me, or for me, I should say. So what is the purpose of doing all this? Where I now notify my opponent of all the witnesses we plan on bringing in, he has to do the same thing. I'll tell you why. It's basically designed to avoid trial by ambush. Now, what is that? In many, many years past, in the old days, there were often times when trial would be by ambush, meaning that each side would bring in witnesses without telling the other side that they were bringing in a particular witness. Then they would have to argue with the judge about why a particular witness should or should not be allowed to testify. Finally, the courts got fed up with this and said, you know what? Now each side has an obligation to notify the other side of whatever witnesses you plan on bringing in at trial. The judge will want to know, okay, counselor, Mr. Plaintiff's attorney, how many witnesses do you have on your case? And now we have to tell the judge, and many times the judge will want to know exactly which witnesses they are. Are they fact witnesses? Are they experts? Are there some other type of witness? And now he will turn to my opponent, the defense attorney, and say the exact same thing. This way, it gives the judge a better understanding of how to schedule these witnesses. It gives the judge a better understanding of how to advise the jury about scheduling. And now everybody is on the same page, knowing exactly which witnesses will be coming in. Also, from a strategic standpoint, if I know that my opponent is bringing in a medical expert the following day, now I know the night before I'm going to be preparing for that testimony, for that cross-examination, for that particular witness. Otherwise, I wouldn't have any clues to who is being produced, and now it becomes much tougher to prepare cross-examination for that particular witness. So why do I share this great information with you? I share it with you just to give you an understanding of how these types of cases work in the state of New York. You know, I realize you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, but you have not yet started a lawsuit and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.